everyone. Thank you for joining us once again to our human rights talk, brought to you by the Center for Human Rights, University of Pretoria. So today our discussion is centered on privacy and data protection in Africa. You would recall that on the 23rd of June, we had our first session on privacy and data protection in Africa, and we had our speakers drawn from the data protection authorities. We had a representative from South Africa, Kenya, Senegal, and then we also had a representative from Morocco. So we had the discussion at that level where we wanted to hear from the data protection authorities how they are managing the COVID-19 situation, but also how the situation is like generally on protection of personal information on the continent. And so today we are having the second part of the discussion. We have practitioners from the continent. We have 3 speakers. We have Amanda, we have Charlie, we also have Ridwan. They will introduce themselves. So, but for now, I just want to say welcome to the talks. My name is Hlengiwe Dube. I also from University of Pretoria. So my work is around managing the expression, information, and digital rights unit at the center, and our work entails those areas: expression, freedom of expression, access to information and digital rights, and privacy and data protection are one of the areas that we work on. So this webinar is part of the work under that unit that we are advancing on privacy and data protection. So I just also want to bring to your attention that beyond this webinar and other activities, we are also going to be having a virtual conference that we'll have around October on data protection and privacy on the continent. We have already sent out a call for abstracts. It's there on our website. We'll also ask our host, Taruna, to also provide the link on the chat section. I think if you continue checking, you'll find the link, the call for the abstract. So on that call, we are asking practitioners, we are asking experts to submit abstracts on data protection, on privacy on the continent. You will see on the call that it is thematic areas that we can focus on. We can focus on the legislative frameworks. You can focus on implementation of those laws. You can focus on COVID-19. You can look at issues on children's privacy or privacy in the context of socio-economic rights. So it is just a broad array of thematic areas that we can focus on. So the objective there is to develop or to contribute to scholarship on data protection and privacy. If you look at other continents, I mean, a lot is happening, a lot is being written, but in Africa, we are still lagging behind. So we are trying to stimulate conversations around these areas, and we are encouraging you to participate, to submit your abstracts. I've already received some. Looks like we've generated a lot of interest. I've received some abstracts, and we're also calling on those that can to submit their abstracts. So without wasting time, we'll start our session. We have 1.5 hours to discuss our issues. We'll discuss the issues from a general perspective, and we'll also then obviously delve into the COVID-19 context. And like I've said, we have our speakers, the 3 of them. I will start off with Amanda. Amanda, please tell us, introduce yourself, give us a very short bio, and then also just a snippet of what Endcode does, your organization. So because we have our participants here who are also interested in building networks and they want to know what your work does, just in case maybe it's worth partnering with you. So I'll start with Amanda.
Thank you, Hlengiwe, for that brief introduction. I am Amanda Manyame, a tech law and policy advisor at Endcode. So I'll give a brief introduction of what Endcode does, but I'll give it with regard to data protection and digital privacy. So with regard to data protection and privacy, we assist our clients with legal management, and we help them to organize and analyze any processing of personal data that they do. We try and align this with the international best practices as well as national best practices and regional best practices. And beyond data protection, Endcode is a tech law and policy advisory consultancy firm that is based in Johannesburg. And our work spans across all the digital rights, that is freedom of expression, data protection, digital commerce, and anything to do with tech law. And we advise on the policy perspective of technology, and we assist our clients to realize any risks that may arise as a result of their technological innovations.
Okay, thank you, Amanda. Charlie, over to you in just less than 2 minutes.
Okay, thank you, Hlengiwe. And after Amanda, I'm Charlie Ngounou. I'm a Francophone. And welcome to all our participants, and thank you, Hlengiwe, for inviting me in this interesting seminar. I was participant at the last one. And so I'm from Cameroon, Central Africa. And, I'm a consultant, actually, created activist, and been involved in this digital right activism and data right activism following the internet shutdown that we had in Cameroon 3-4 years back. And today I normally work as coordinator of the Moderator, a network of organizations, companies, and individuals in promoting a human-based data economy, not just taking the side of data protection, but actually, promoting the economic value of data sharing, data flows, between countries and so on. And that's the work that we do, and we are trying through My Data Africa that I lead to, to build a movement in Africa so that we can actually reap the benefits of, personal data. I'm also in Cameroon. I'm also involved with the working group on data, working on data protection. So I will have to talk a bit about that in a while after all of it.
Thank you, Charlie. Ridwan, the same for you, the introduction, briefly.
Yeah, thank you, Lemon. Yeah, my name is Ridwan Oloyede. I lead the privacy and data protection team at TechHive Advisory, Nigeria. And what we do at TechHive is that we're a technology advisory firm focus with key focus areas around intersection of business, law, and technology. And part of what we do is privacy and data protection, cybersecurity, startup advisory and emerging businesses, and a lot of policy and research. So what we've done so far is we've been able to, aside advising, do a lot of business advisory, supporting clients with implementation of our privacy program, and of course, also supporting some way by doing auditing and some other data protection specific tasks. We also do a lot of guides just to shape conversation and also to bring a lot of clarity to so many gray areas within data protection from Nigeria and also across the rest of the continent. So we've done working papers, published guides, we've published different reports on different aspects of privacy. So that's what we do at TechHive Advisory. Thank you.
Thank you very much, Ridwan. So for our participants, there is a poll that will pop up on your screen. Please kindly participate and give us your views, and kindly keep your microphone muted and your video as well. And please note that this session is being recorded and the video will be made available, I think in a week or less. And also make use of the chat section. We want this conversation to be as interactive as possible. Ask your questions and also your comments as well. So yeah, so I'll start off with my first question to my speakers. Let's start off with the general aspect, issues of privacy, issues of data protection. How are they understood in Africa? Do people generally understand issues on data protection and privacy? I'll start with Charlie. And just address us in like 2 minutes. It doesn't have to be long.
Yeah. Okay. In fact, I think, do you follow me? Okay. In fact, I think data protection in our context is not yet, it's not yet a common people thing. It is not a general conversation that is being pushed by the states, and it is just normal that we don't say this in the street. People are more concerned about using apps, using apps to feed their needs, their daily needs. So the issue of data, of protecting data, is not yet something that has been adopted by people. And you see this from the behavior that you have on social media. So you see clearly that people don't really care about what their data become after or maybe during their use of most of the apps that you have there, Facebook, WhatsApp, or social, or Instagram, or any other thing. So this is a conversation that we need to take from the experts, from those who are very much involved in this, to bring it to the street, to make it a general man, general woman, issue. That's what I can say about in general, as an introduction to this meeting.
Thank you very much, Charlie, for that intervention. And Charlie is of the idea that we are not yet there when it comes to these issues around privacy and data protection. Amanda, are you having the same sentiments?
Definitely, I do have the same sentiments. I believe that a lot of individuals, citizens, whether it's on the continent in Africa or abroad, don't have an understanding of what data privacy is. And if you may allow me in at least a minute, where data protection comes from, it's your right to dignity. So when you protect your privacy, you in essence protect your dignity. But with time, now that all our information is out there on your Facebook, on WhatsApp, on any other social media platform you use, or your emails, now we need to protect our personal data, and that is this information that pertains to who you are as an individual. So this is why it's important that we protect individuals' personal data. But then, like Charlie said, people are willing to give away that personal data because they want to maybe use the application that they have signed up for, or they like something in return for that personal data, without understanding that that personal data can be used for other means, that personal data can be misused, and in essence, your right to privacy will be violated. Thanks, Hlengiwe.
Okay, thank you. Ridwan as well, who also would like to get your view on that aspect.
Yeah, thank you. It's pretty much a nascent phenomenon. I mean, data protection specifically. When we speak to privacy, that even some will tell you there's no such concept of privacy in the African context because of maybe the arguments around communal way of living. But also these are arguments that are actually quite very subjective. But also, if you look at the broader view, look at how we've continued to adopt technology and how we continue to, that's how we'll continue to increase the use of technology. The threat landscape is the same everywhere. And of course, it means we simply need to be more aware about what the risks are, what the danger are, what the vulnerabilities are. So from a user point of view, we need to know, we need to be aware. I mean, there is a whole lot of conversation where people say things like, what do I have to lose? What do I have to lose? And when people say, what do I have to lose? You get scared when you understand what they truly are losing by saying what they have to lose. So there's a lot of risk, there's a lot of vulnerabilities. But I think the consciousness is growing, and we have to be candid. More African countries are adopting laws. More African countries are daring to set up their data protection authorities. So I would just hope maybe over the next few years, we see more adoptions of law across the continent.
Thank you, Ridwan. So just in our chat there, Chennai is raising, I think, a very important question. We'll allow our participants to respond to that. She's asking, is it a lack of understanding of privacy, or is it how the experts conceptualize privacy? She then says, studies have shown great awareness of privacy concerns. It's more of how you ensure your privacy. So is it about lack of understanding of privacy, or how the experts conceptualize privacy? That's the question. We'll start with Amanda.
Say both. I'd say both, because you find that now studies have shown that we need to educate the parents and not the children. So I find that the younger generation generally understands what data privacy is. They also understand how to protect themselves when they're online. And then you find the rest of us that are a little bit older, we have struggled to understand this concept of privacy online.
Okay. I think I'll then move on to the next issue. If we are looking at the framework that we have currently on the continent, I would like you to comment on the Continental Convention on cybersecurity and data protection. Do you think that that's a good yardstick to use at the moment? Are there any loopholes that you find on that framework? And then also beyond the convention, also let's have a discussion around our sub-regional frameworks. The Southern African, we have model laws that have been adopted by SADC, the model law on data protection, we have model laws on cybercrime, on e-commerce, and then we also have, in West Africa, we have also a supplementary law on data, on data protection. Do you think those provide enough guidance or appropriate guidance to state parties to emulate or to draw from when they formulate their data protection laws? I will start off with Ridwan.
All right, thank you. Yeah, so I think one important thing we shouldn't do is our own context in Africa, looking at the development of what the status of data protection is in terms of development. I think it would be unfair on us to compare ourselves with other parts of the world that have actually been doing data protection for decades. So also, like you said, it's suggestive enough. If you look at whether it's the African Union instruments or the SADC or ECOWAS or EAC, the instruments. So these laws, these instruments have actually given some sort of an idea of okay, what states could do. And for the fact that with the current state of things and the current trend, there's a mismatch between what those instruments suggest and the modern trend of, the existing trend of things. There's a mismatch of reality. So, but for me, I think it's a conversation starter. And I think if we, for example, as if more countries actually model their law after this, I think is a first spot to start. Then we can start talking about, okay, how do we bring these laws closer to reality? How do we bring these laws to ensure they actually truly protect the people they say how to protect? So also another thing we should also focus is there's a lot of arguments around harmonization of data protection laws on the continent. And this has become even more important with also how can we maximize the digital economy aspect of the Continental Free Trade Agreement. What we see with that is the fact that there's going to be a lot of cross-border data transfer. And as the exporting country, I want to be concerned about what protection are in place in another country where the data of people residents in my country is going. I want to be concerned about that. If I probably find out that you probably don't have an adequate framework, I'm concerned. And that itself could actually impact digital trade. So we need data, we need free mobility of data. We need more countries to adopt some sort of a law, set up their data, because it's not enough to set up to have a law. You need to set up a data protection authority to actually enforce this. For me, I think the laws are suggestive enough. And another thing we should bear in mind also is the fact that our lawmaking process in Africa is quite different from maybe what you have in the EU, for example, where by making a regulation, it only takes other member countries to transpose it into their local laws, and it becomes effective. For the African Union Convention, for example, it needs 15 ratifications come into force, and we have just about 5 this time. So our lawmaking process is also different. The most important thing is the suggestions that these laws have given. We need to start from there. Make sure we have more countries actually adopting laws and setting up data protection authorities to truly protect people they want to serve.
Okay, thank you. Charlie, what's your view on the issues that I've just raised, on these frameworks that we currently have? Do they provide enough guidance?
Thank you. I will support what Ridwan just said, but talking from the perspective of someone living in Central Africa, I will say that when you look at countries in this region, you will see clearly that there are some countries that are making kind of strides. You know, in Central Africa right now, apart from Cameroon and Central African Republic, you will see that Chad, Gabon, Congo, Guinea, they have adopted already data protection laws. And this means clearly that there is kind of awareness at the level of, you know, our government, our leaders, so that we are actually very much concerned about protecting data. And I agree with the fact that this awareness is still at the level of those who are experts. As you might take it from the government or from those who are great big businesses, multinationals. Those are the ones that care about these data protections laws. But what we see from all those legislations is that, you know, given the trends, the technological trends, and even the juridical trends that we see all over the world, and given the fragmentation of African countries and the kind of, you know, power sharing that we have between other jurisdictions and most of our countries in Africa, there is a need, you know, there is a need to make sure we have a framework that encompasses, you know, our teeny countries. Because when I take GDPR, for example, you know, that defend and protect personal data for Europeans, for example. What can a country like Cameroon does in that kind of relationship? We are very weak, and it doesn't just it doesn't just concern this aspect of data protection. When you will take some other sector, economic sector, and anyone that you want, you will say that we don't have the power, you know, the true power to make the most benefits of all these instruments. So there is a need for all of our countries, you know, to adopt those continent-wide framework that will give them more power, more bargaining power when we want to defend our own economies, our own companies, or maybe when we want to protect our citizens. That's my view on this. This adoption, you know, these usual adoptions of countries' laws, you know, specific fragmented countries' laws, even though it is based on AU convention, it's not that sufficient, because what we see is that we are going just alone against jurisdictions that are bigger and far more powerful than we are. And the economy today, when most of these laws or conventions were drafted, you know, the economy, the state of economy or the state of technology was not the same that we have today. When you look at profiling, for example, and the kind of data, you know, data harvesting and data mining that is going on from those big multinationals that work without, you know, they don't even care about borders. You know, talking just of countries make very little sense for them. Facebook has no affiliates in Cameroon, for example, or in any Central African country, but he is one of those companies that are using our data, and we are not even aware of what is going on down there, what is going on in the back office. So there is a need for our leaders in Africa to make sure that we can have, you know, a very solid, adapted and adjusted framework that will see the things in, you know, in trying to build a powerful framework that will give us more bargaining power in this, because it's actually a warfare.
Okay, thank you very much, Charlie. There are interesting questions that are being raised. Amanda, I'll give you an opportunity to also address us on the SADC framework, the SADC model laws, and also maybe if you also want to comment on the African Union Convention as well. But on the chat section here, there is a question from Diana, and whilst Amanda is responding, you can be thinking about it. So Diana is saying, do you think that African states should adopt the European Union framework on data protection? Or is there a different context that should be considered? If so, what is that different context in your view? So that is the question from Diana about whether we should also be adopting such kinds of frameworks. So Amanda, what's your view regarding the present frameworks that we have on the continent and in the sub-region?
In the sub-region, we have the SADC model law on data protection. So this model law is like most data protection laws and model laws, but my one critique would be that we need meaningful accountability. And the reason I say this is because, for example, for you to be able to process someone's personal data in terms of the SADC model law and in terms of most of the data protection laws, you would need that person to consent to it. But a lot of people don't necessarily understand what those terms and conditions or the privacy policies say about how this company or this app is going to use their personal data. So we need an entity that is processing this personal data and collecting this personal data to be firstly accountable, so that even if I don't read these terms and conditions and privacy policies, I know for a fact that should this entity misuse or abuse my personal data, then they will be held to account by hopefully a data protection or authority within my country or within the sub-region if it's SADC. So that is one of the issues that I have with the SADC data protection model law, and it's also an issue that we're seeing in a lot of national data protection laws. Thank you, Hlengiwe.
Okay, so yes, now we go to Diana's question. Do you think that African countries should be using the European framework, adopt the European framework on data protection? Ridwan.
Yeah, I said earlier that it would be unfair on ourselves to draw that parallel, and that's because of the state of development. But also, what we should, for me, I don't think we can take relevant provisions that suit our local context, because one thing that is always very important is to make sure we don't ignore local context. So, for example, if you're trying to operationalize things like even let me say a more complex concept like I really don't know where to place the example, but what I'm saying in essence is these are institutions that have been built over years, and we're still grappling with the fact that we've got countries like Uganda, we've got countries like Botswana who have data protection laws and are not able to set up their own data protection authorities, for example. Botswana, for example, I think passed its law in 2018, if I'm correct. This 2020, no data protection authority. So, for example, that law itself by now might probably even be due for amendments to start with. If you look at the content of the Ugandan data protection law, for example, to even fit into the modern context. So I think for us, it's important for us to grow within our local context. And that's also the fact that we're not ignoring the fact that, we're not ignoring the simple fact that technology is somewhat an equalizer. The risks are the same. The exposure is the same. If you're building a smart city project in Africa, the same risk, the same assessment, the same impact assessment that you should do is the same that you need in any other part of the world. But also, we shouldn't ignore our local context, because as the privacy, the famed privacy preserving browser actually looked at there was 28 data protection that looked at data protection authorities in Europe and looked at and part of the problems they identified was the fact that there are even some that even have institutional in terms of staffing. So there are data protection authorities who staffing the way they've done their staffing is they don't even have people who have the core technical skills to do the job, or they are largely understaffed, or they are even unable to even, and that's why you see some of them getting criticism. For example, the Irish Data Protection Authority didn't issue its first sanction until a few months back. The ICO is taking a lot of heat from a lot of people because so many complaints are being filed, no sanctions. What you have is just mere notice of enforcement for the bigger ones. There have a number of sanctions, but notice of enforcement for, let's say, something like BA, something like Marriott, for example. So there's those problems there in terms of even how these data protection authorities function, capacity, funding. So there are so many problems itself. So for me, I think we can take the good parts, but we shouldn't ignore our local context while we're doing this too.
Thank you, Ridwan. Chani, what is the importance of a data protection law? And if you are looking at our African context and the issues that we have been discussing, there is a question on the chat section there that is saying, are there any other obstacles in African countries that hinder the adoption of effective data protection frameworks? Is there a need, for example, for capacity building through training or legal professions? So address us on the importance of that data protection law. So what does it help? What are the implications of not having one? And what are the implications of having one? And also in terms of enforcement, what are the obstacles? What do we need?
Thank you. And yes, I see the question, and I think it's a very much interesting question. And there are so many obstacles, and those are, those stems from our history. The thing is that when we talk of data protection, we are talking of issue of rights. And in most of our countries, and this issue, because of the pace of technology, are just, falling on us, and it asks us to accelerate the way our pace also, to adopting all those measures, maybe to frame our own our own legal instruments, to protect our countries. The thing is that most of our countries have not been that proactive in adopting human rights instruments that has been set in globally. That's the issue that we have. And most of our countries has been, as you know, when you look at some other rights, human rights that are also included in this issue of that data protection, you will see clearly that most of our countries has been reluctant to use or maybe to make use of human rights, the human rights instrument. They have been reluctant to, to educate citizens around human rights issue. For why? Political issues, political gains, trying to fake human rights in our countries have set off in a kind of unpreparedness when it comes to this kind of rights where we are on the weaker side of the equation. Because when we talk of our data protection, we are not, as African citizens, living in context where technology is not actually built. We are just consumers of technology. That means we are the weaker member of this equation. Also, so we are building data protection, not in the sense some other are building data protection in their countries. When you look at GDPR and when you look at CCPA, or when you look at the Chinese data protection, you see clearly that there are very great economic motives behind those data protection. It's not just, those are not just issues, that relates to security, national security or confidentiality. When you look at our data protections, or most of those instruments that we build, not actually entitled data protection, but let's say law on communication, on electronic communication, electronic commerce, and so on, you will see clearly that there is a bias that leads us to be thinking of these issues, of these instruments in the sense of security, national security, national, public security, confidentiality. Those are the issues where we stick the most. And if we want actually to protect our countries and then to build the space to reap the benefits, to reap the most benefits of data, because data today is the power, there is a paradigm shift that we need in our country, to take human rights, because we cannot fragment human rights. Human rights is an anatomic issue, as we say in computers. It's an atomic issue. You can be spearheading data protection laws when you have problems with democracy, when you have problems with protecting citizens. So that's the problem that we have. And we are in the middle of the sea. We don't actually know where to start with. And that's my own issue. And so to reply to the question, what are other obstacles? I would say our obstacles is the level of governance. The main obstacle is the level of governance and the level of political will to create a space that is free, that is truly free, and that will give to citizens, kind of demeanor to go to love this issue of protecting our rights and to shift the mind, to shift the mind to looking at what can, as an African citizen, we can do in this battle, because it's a battle for data now. We see Chinese colonizing our data. We see Western countries doing that. We see Americans doing that. We need to know this. And so our leaders need to understand that it's not an issue of staying in power or maybe protecting power. It's an issue of protecting African resources. That's my issue here.
Thank you, Charlie, for that elaborate contribution. I'll move on to Amanda. I'll also use the question that I'm seeing on the chat. Interesting questions that are being raised here. So one of the questions from Barry, what is the risk for countries to adopt different laws on business, tourism, and individual rights? Should we think of promoting a model law or regime for continental integration? and how does imperialism play out in pushing for some frameworks such as the GDPR, for example. It's quite a long question, but you can pick up some aspects that you can respond to.
All right, I will pick up the first part about the risks of different laws on business tourism, individual rights. I think this is one of the issues that as a continent we need to think about because of emerging technologies. The business tourism, different rights, it is kind of morphing into one form of industry. So for example, if you look at the health industry, you now find that you have health tech where people's health data is now being not processed by hospitals or medical institutions, but it's now being processed by tech companies. And those tech companies are not covered or regulated in terms of health laws. So now you find that you would need a data protection law that now deals with the processing of that health data being processed by a tech company instead of a hospital or a medical institution. So there is a danger in that we have different laws that are dealing with different aspects of life, whereas we are moving to a stage in our lives where everything is beginning to morph into one form of industry, and most of it is being tech-driven. So that is one problem that the continent would have to deal with. And you also have to consider the fact that we still need to look at those individual laws, for example, the individual rights that are being governed by the different laws. So we still need to deal with, do those individual laws cover all the necessary aspects with regards to the different individual rights before we even talk about amending these laws or coming up with new or different laws that account for technological innovation. And well, there's different parts of the question, but I think I'll stop with you.
Okay, I think in the interest of time, yes, we'll proceed. So Ridwan, please apprise us of the situation that is currently pertaining in Nigeria with regards data protection law. Where does Nigeria stand at the moment?
Okay, so last year, the ICT agency, that's the National Information Technology Development Agency, released a data protection regulation. It's a subsidiary legislation. So, and essentially, that's like the main law that we have right now, regulating data protection in Nigeria. So, and there's always been question around why do you have to use a secondary legislation to shape something this important. Also last year, we had a Nigerian data protection bill that was sent to the president for assent. That was around May last year, but the president did not sign and he did not reject it. So pretty much uncertain about the fate of the bill itself. So prior to even the enactment of the regulation, what we had in Nigeria was more of a sector-specific driven framework. You have the telecommunication sector having some sort of a guideline or regulation. You have CBN pushing out the Credit Reporting Act that expressly makes provision for data protection. There was the National Health Act, for example, that was strictly regulating privacy in healthcare. So we had like a number of laws around different sectors and spaces like that. But the problem with having pockets of law about is also the fact that there is an uncertainty. Sometimes it's unclear on who the regulator is. And pretty much it felt like the right was non-existent because it was so difficult to enforce them. So what we're seeing, the change you're seeing now is we're having more cases in courts. There are a number of cases currently challenging even some foreign-based companies like Zoom, TikTok, Truecaller in Nigeria for violation of privacy based on the regulation. We're also seeing, because of what the regulator is doing, we're also seeing more drive by, let me say, key sectors, companies in key sectors who are trying to gear towards some sort of compliance. So in Nigeria, it's not the best, but we're trying to drive, the country is trying to drive it bit by bit. But ultimately, what we still need is a proper data protection and creating an independent government, an independent supervisory authority, because the current agency regulating it is not so independent. If we look at the ECOWAS Supplementary Act, for example, it seeks creation of independent supervisory authority, which is similar to what you have under the African Convention and also the Council of Europe Modernized Convention, for example. So you can be an independent authority if you're not, if the constitution of your body, example, is made up of members of the government. So NIDA, which is the agency regulating government, its body is made up by so many members of the executive arm of the government. So it simply means it lacks independence. And what we've seen also is the fact that there have been a number of notices of enforcement that have been announced against government agencies. And at some point, we just noticed there was no sanction, simply because maybe they possibly couldn't sanction this government agency. I myself have filed a complaint to NIDA against the government agency. And since last year that I filed it, this has not been resolved. The problem is still there. So lack of independence is still a problem, but ultimately, like I said, having a proper data protection act, creating an independent supervisory authority will draw us closer to what the ideal, almost.
Okay, thank you very much, Ridwan, for giving us at least the Nigerian perspective. So in Cameroon at the moment, we don't have like that data protection law at the moment. So what is happening at the moment? Are there any other laws that are in place? Ali?
Yeah, thank you, Hlengiwe. Actually, we are currently drafting our bill. And that's been led by the Minister of Post and Telecommunication that is in charge of digital strategy in our country. And so there is a working group mostly involving public servants, actually. And this is, for me, it's something that is just sad, because data protection is not only a right issue. It encompasses so many other sectors, and mainly, economic issues, technological issues, so many other mindset will have been brought to this working group. And so I'm part of the working group as a representative of civil society. But meanwhile, while we are working hard and fast, to set the bill to the Prime Minister, there are so many other instruments in Cameroon, giving us the sense to think that data protection and privacy are enshrined, in the Constitution. But most of those laws, as I previously said, in the perspective of, national security, in this negative mindset, we need laws that allow us, to provide for kind of free flow of information, of data protection, because we can't prevent multinationals from using our data. That's impossible. We need to acknowledge that. We need to admit that is impossible. And what we've noticed when you look at the history of technology is that we are running after technologies. They are in a kind of, very close box, thinking and building technologies that make use of our data before we are even aware of it. So it's kind of a blind battle that we are doing, that we are involved in. So in Cameroon, we are trying to push this very, very, very fast. And I also see the kind of difficulties that we have in the working group, because you have people that are very much stick to this issue of national security and so on. But I don't see what is the issue with national security when we don't even, all our data, when I see our government using emails, and as now we are using Zoom, in this time of COVID-19, we are using Zoom and so on. They don't even know where these Zoom data are being stored. what kind of data protect, or maybe national security, public security we are talking in this technological time? We need to come to the awareness, great awareness that there is actually no enemy in our country. The fight today is a very, very heated economic fight between those who are ripping our data out of our knowledge and people like us, African citizens, who are just consuming applications and technologies that we don't know all the intricacies. That's our issue. So that's the kind of flavor that I try to bring in the working group, trying to tell that our main goal is to see how we can take the most, economically speaking, from the use of our data, so that we can stand in front of those multinationals and tell them that this is what we want. You are using our data. This is our, this is what we think you need to share with us. And just to, as I finish this, I wanted to give another obstacle to the fact that most laws are not enforced, just to follow Ridwan. The thing is that when you look at telecommunication sector in most African countries, some of those who are our leaders are somehow shareholders in some of those telcos companies. So how will you enforce those laws when some of those who draft laws or who vote laws are actually the benefitors of those companies? That's the kind of question that I would like to end with.
Wow. Thank you very much for that elaborate and passionate intervention. So somebody raised a question earlier on in the discussion. They say that, so with regards to these apps that we are using that are collecting so much data, our personal information, would you recommend that we stop using these applications? Usually the phone applications leave one with no option but to accept the terms and conditions. So that is one of the questions that has been raised there. But coming to you, Amanda, the South African situation is such that 2013 we had the Protection of Personal Information Act, but it hadn't been enforced for up to that. So now there are new developments that have taken place. Can you give us like an overview of what is currently happening in South Africa with regards protection of personal information in the, or the data protection framework?
Okay, thank you. So as of 2013, South Africa had this Protection of Personal Information Act, but this act was not fully in effect. That is, the provisions that provide for the processing of personal data were not in effect until the 1st of July this year. So as from the 1st of July, South Africa now officially has a data protection law that will hold any entity that processes personal information to account. But you still have a 12-month period from 1 July until 2021 at the end of June for you as a data controller to comply with the provisions of this data protection law. So that leaves us in a space of, we do have a data protection law, but you still have a grace period of 12 months to comply. The information regulator has stated as of last week that we've had this data protection law since 2013. So data controllers should by now be able to comply, because we've known for some years now that this data protection law is going to come into effect. But in terms of the act, officially you have 12 months to comply. So a lot of people are now asking what then happens as a data controller or as an organization that processes personal information. What happens if I have not complied with the provisions of this data protection law? How will the information regulator hold me to account? Would they ask me to just make sure that I comply by the end of this 12-month period? So those are some of the questions that are in play at the moment. I don't know if Hlengiwe, you want me to go into what's happening now with contact tracing?
No, we are now getting into the conversation around COVID-19. We are left with 30 minutes. So let me see if there is a question that is with, but maybe with regards to COVID-19, to our speakers, I would like to address the way what is happening in your countries, or you can even make reference to other jurisdictions as well. Like, since Amanda, you had already started, I'll start off with you. If you're looking at the South African situation, what really can you say South Africa is doing well in terms of protecting personal information during this pandemic? And what are those areas that you think South Africa could have done better?
So firstly, I think South Africa has done well in that when it provided for contact tracing, it also provided for the processing of this information that is going to form part of the contact tracing database. So the regulations stated that this database, firstly, is confidential. Secondly, no one is authorized to share information from this database unless this person has the right to do so, or it is going to save lives with regard to COVID-19. Also, the regulations requested that there should be a judge that is designated to oversee this contact tracing database. And this judge was appointed a few days after. And I must note that this Judge Reagan, she is quite well known for data privacy, and she has pushed for the protection of the right to privacy for quite some years now. So that was a really great win for data protection. However, I would have liked to see more done in terms of protect this COVID-19 database. I'll call it that. The reason I say that is because in the regulations, all that they say is we have a judge that should make sure that this information is being processed well, but the judge is only overseeing an aspect of this information, and that aspect is the information that is coming from the telecommunications service providers, as well as the what you ought to call them your Facebooks or the WhatsApp. So information coming from those is the ones that she's overseeing, and then the rest of the database is merely confidential. It says nothing with regard to how this information should be processed. It says nothing about you informing this particular person that we've collected your information. Where is your information being stored? Who has your information? Has it now gone to a third party, and who's this third party? It says nothing about security with regards to this information. What should happen if you have a data breach? And there was a data breach on the 9th of June with one of the largest hospitals in the country. So these regulations do not call for that. They didn't say anything that is provided for in the South African Data Protection Act. So I would have loved to see them taking the processing principles from the South African Data Protection Act and putting them into this regulation, considering that at the time of passing of the regulations, the South African Data Protection Act was not yet in effect. It only came into effect on the 1st of July. Now, the problem with that is you have that 12-month grace period that I spoke about. So an organization, an entity that has collected this information might not comply with the lawful processing provisions that are provided for in the Data Protection Act, and which is now a problem. Also, and lastly, the regulations state that once this national state of disaster has come to an end, this database should be de-identified. So all that the information that is in the database is either destroyed, or if you want to use it for research purposes, you should make sure that you've removed any aspects of the information that could point to an individual. So once you've done that, it is all good and well, but the problem is that with the way that data is processed these days, it's relatively easy for an organization to be able to say, this is this person's data and that is that person's data. So I'd love to see a little bit more with regard to the processing of personal data and health data that is in this contact tracing database? Thanks, Hlengiwe.
Thank you very much, Amanda. So, Charlie, in Cameroon, COVID-19 found Cameroon without a data protection law. What does it mean in terms of people's personal information? There's a lot of information that is being collected. Contact tracing is taking place. Now economies are being, the lockdown regulations are being relaxed. Businesses are opening. And still, that involves a lot of information that is being collected, and it finds Cameroon in such kind of a framework. Please address us on what's currently happening in Cameroon and what are the challenges that have been encountered because of the current framework.
Thank you. And the thing is that even though we don't have a comprehensive data protection law, as we previously said, the thing is that for different sectors, we have laws that that can give a kind of protection. The issue is that those laws don't actually talk about, I think the main limitation of those laws is that they were not built, for this data protection issue. They were not built to protect our data from those who harvest and those who do this kind of very complex technological profiling, because the way we see data protection in the sense of telecommunication sector or the banking system. For me, the banking system is where you have the best of these seemingly data protection laws, because that they talk of money, they collect your data, they have to follow you to make sure that you give back your loans and so on. This comprehensive law. And for data that are being collected, we can't even say that we are protected, even though we have those provisions, because as Ridwan just said, and I would like to support that, and if you don't have kind of independency for those, for those set of judiciary, executive, and and legislative, those who are the one that should be, overseeing themselves to make sure that what is in the law is really enforced, and that if there is a breach somewhere, or maybe a damage, or maybe a distortion in your data, that you can really take out some measures to, to ensure that there is a repair for what has been done. So you can. In Cameroon for now, most data that are being collected are just collected, and we, those data are collected when we need a service. And quality of service, or maybe benefiting of kind of service, it's actually not that a given. So you are, most of the time, you are concerned about receiving the service, and that's all for you. It means if you get to let's say an hospital, and they want to collect anything from you, you don't care for what is going on after with your data, because you need to, you are sick and you want to receive health, services. So you won't add this issue of data protection between you and the physician, because you are at the weaker side of the equation, as I always used to say. So for now, we need you here. What you will see is clear that we don't have it. I don't know. In Nigeria, I think there was an attempt to build one, but I'm not sure that it was really achieved. But in Cameroon and in most Central Africa, and in all this Central Africa region, we don't have a contact tracing app for this COVID-19. And also it gave a sense of the way we have dealt with the COVID pandemic. It means we were not prepared. And our technological adoption, the resources that we have, the position we are now in this global technological development cannot give us to build this kind of app now. And this might show us that we need to move very fast to be prepared for the next pandemic, next crisis that might come. Because the truth is that technology is a game changer. If we don't use technology, that's my religion. There are people who are not of this religion, but my religion is that technology is a very good game changer, but it needs to be used in a space of trust. It needs to be used. You can be using technology in this kind of political nightmare we are in, when we are trying to be open while at the same time we are closed, politically speaking. That's my view. We need an enabling environment, and building all those instruments are the way to. Thank you.
Okay, so Charlie emphasizes the need for an enabling environment, and also he raises very important issues around technology. So Ridwan, with regards to Nigeria and in terms of COVID-19, what are the privacy and data protection issues that arise, and how have they been handled? You can mention issues around contact tracing, you can also digital surveillance, and to what extent has Nigeria been harnessing technologies in this regard, and what are the implications on privacy?
All right, thank you. Just like a couple of other African countries like South Africa, Mauritius, Burkina Faso, Mali, Morocco, Tunisia, I think Cape Verde, we issued some sort of guidance. Senegal too, yeah, they issued some sort of guidance for around COVID-19 and processing of data. What Nigerian government did at the very early stage, even before the lockdown, was the Data Protection Agency issued a statement saying processing of collection of, at the point of entry, the collection of data at that point can be processed on the basis of public interest and I think legal obligation. That was the only statement as far as the data protection, the agency acting as the data protection authority is concerned. But there are a number of issues around employee-employer concerns, around even workplace surveillance. There's been questions around. So part of what we've done at TechHive is also to look at, there have been adoption of self-triaging applications by state governments and also by the federal government. So what we did was we actually looked at two self-assessment apps developed by two different state governments in Nigeria. And we considered the standards that was used to a couple of privacy standards, and what we found was quite was a disaster. Let me just put it that way mildly. That's mildly to put it. In one of the apps it was a third-party app, not available on any of the verifiable app markets. So what we found while looking at the particular app is that even the web version of it it's not even built on a website that has an SSL to start with. It's a third-party app which in itself has its own risk. There was no privacy notice. It was taking so much information from people without any sort of safeguards or anything. The other one itself, there was a privacy notice, but the privacy notice belonged to another company. So when I said it was a disaster, it was a complete disaster, what we found out. So currently the CDC, which is the Center for Disease Control, actually adopted another self-assessment app, which is actually way better than the two adopted by the state governments. Currently, we've not looked at that, but my initial assessment is at least it has a privacy notice to start with, and it's not as intrusive as, those ones built by the state governments. So as a country, we're here to adopt a contract tracing app like we've seen in Botswana more recently. So there are a number of issues people are scared about, even some of this that have been available in terms of maybe those who've conducted tests. How long are we holding this? Are we holding this beyond period of the COVID-19? Are we Do we intend to use hold on to them to use it to even manage some sort of disaster that will probably come afterwards? So part of what we've also addressed is also issuing a working paper, which we've made a couple of recommendations to the regulator, for example, on how to efficiently manage some of these spillover and some of these concerns as well. So, but one thing that is very important that we continue to reiterate is the fact that we shouldn't ignore the role of human rights in terms of course, we have a public health crisis, but of course, we shouldn't ignore the role of human rights. So, from my own point of view, there hasn't been so much of technological adoption in terms of finding a solution in terms of maybe using a contact tracing app or any of those things. What we have at best currently is the self-assessment app that's just been adopted by the Center for Disease Control.
Thank you, Ridwan, for that intervention and giving us how the situation is like in Nigeria and some of this. So what we are realizing, I guess, from the interventions is that whilst there are efforts that are being made, COVID-19 kind of exposes us as Africans how not prepared we were, how not ready, whether it's COVID-19 or any other issue in terms of data protection and in terms of privacy. We still have a long way to go, and there's a lot of work that needs to be done, and there are issues around balancing also the right to privacy and national security, and when we're looking at Charlie's presentation, that is coming out strongly in the way it's playing out in the drafting of the law in Cameroon, and that is not only unique to Cameroon, it's also something that we witness in other countries as well. So hence it shows us the importance of continuously engaging on these issues. So there's a question, one of the questions is in French. I think, Charlie, maybe you, somebody is raising a question in French, maybe you see it there, you can respond. But one of the questions that has been raised is actually a comment. The person is saying that we need to fight against data colonization. This is my prominent take on this issue of data protection. We need to have an economic perspective on this issue, because while we take our time, current winners are actually winning all and structuring the future. And there's one question that I think I have missed there. Okay, yes, it was about the extraterritorial application of GDPR. So it's Johannes, and he's saying that, how do we see the extraterritorial application of GDPR in Africa, where African states have maintained trade ties with EU? Do you think the commitment, don't you think the overcommitment is a stumbling block? Extraterritorial application of the GDPR. We can have just 1 minute interventions from all of you on this. Amanda?
That's a very good question, purely because the GDPR, well, any law, any national law or any regional law cannot apply unless another third-party nation decides that it applies with them. So for the GDPR to apply, let's say in South Africa, or to apply to a South African company, that company would have to have entered into some form of an agreement, and usually in the form of contracts with an entity that is based in the EU. So is it a stumbling block? Yes and no. If you wanted to apply to it, it might count as a stumbling block. For trade purposes, the EU who in all likelihood prefer to trade with an entity or with a nation that is GDPR compliant. So in that regard, it is definitely a stumbling block. Which is why I believe that, well, Africa as a continent, we also do need to have our own data protection framework, whether it is the AUCC or we amend that or have some other form of framework that guides what is Africa's stand when it comes to the processing of personal information belonging to African citizens in Africa and outside of Africa. Thanks, Hlengiwe.
Charlie?
My view is that we will certainly have to build, as I would talk as a civil society activist, we will certainly have to build a broad continental-wide movement, you know, to push our legal actors, our executive, those who are decision makers today, because what they decide today is shaping our future. And as I said in the chat, I don't understand why in these 2020s, you will have executive and legal actors, or maybe, these legislators that will be so reluctant to adopt very fast laws that protect our interests. That's where we need as citizens, to coalesce and ask for protective regulations, because maybe those who lead us, as they don't have any problem, they have their interests already filled and already fed. We need, as those who will be lost tomorrow when all those great technological powers will have shaped our future. We need to make sure that in shaping this future that we are involved. And this will ask us to ask to not only local legislators, not only national legislators, but those legislators at the level of African Union. I can understand that since 2014, today only 5 countries have signed the convention. It's incredible. And this is not even this is not even a law that is against someone's political interest. This law doesn't even address the issue of replacing someone who is in power since, I don't know, 20, 30. This has nothing to do with that. And even in this political natural law, you see countries being reluctant. Meanwhile, we are losing ground, on this issue of data power. We are losing ground. So we need a great vocal movement of civil society to talk of this. It is not acceptable. We can't be just looking at this passively. And we have 54 countries, and from now, and so far ratified, and only 5 that have signed it. It is not that normal. So those who lead us are not serious at all. When they talk of digital issues, data protection, they are just coping with formal movement. Just that they don't have the spirit that we need to adjust to this new global world order. That's what I can say on this.
Yes, again, thank you, Charlie, for that. You are mentioning very important issues around political will that are very important. And with Ridwan, can you please comment on issues around data localization, especially with regards to COVID-19, and also maybe briefly on security of personal information, but most importantly, data localization.
All right, thank you. Yeah, so there's always been argument around data localization, and for me, I'm one of those who are I find firmly against data localization, because I feel it has bad economic results. So, for example, the Nigerian Data Protection Bill that wasn't signed by the president last year had a provision around data localization, which was going to impose sanctions of about 8 billion naira. That's a lot of money. That's well over $20 million if you try to convert it to naira. Locally. So, but what we have also ignored is the fact that Nigerian infrastructure is still a problem, power is still a problem. So the cost of hosting data locally will be too expensive. And also, if you look at those, the fine, for example, it also had the option of maybe 8 years imprisonment. It simply means technically the regulator will be killing all small and medium-sized businesses who are unable to afford to store their data locally. So for me, I feel data localization ought, because it's very important. We need that free mobility of data to trade with ourselves. We need that free mobility of data to access some services. So if you want to store it locally and you want to keep it in country, I don't think how it really helps your economy. For example, if you're really trying to max out, if you're trying to maximize or optimize the potential of what digital economy could bring to you. So also around security, often than not, there's always a mistake around, and which is part of what Charlie, government attitude responding to data protection, but also trying to like fuse it with cybersecurity. Security is a principle under data protection, but it's not entirely what data protection really is about. It's just one principle under it. So, and that's what we've seen with the law in Zimbabwe, for example. That's the attitude in Chad, for example. NIDA, which is also the data protection agency in Nigeria, itself also has a cybersecurity strategy. A policy on cybersecurity. So you can't trying to do the same. And this is part of what we've been working on with Endcode to make sure we push out something around this. We can't fuse the two. The independence is watered down, the efficiency is watered down, and that's more, we'll probably end up creating more problems because we continue to see things from the national security prism, and ignoring protecting the people, protecting human rights, safeguarding human rights, which is actually the most important thing in the picture right this time around. So that's it for me. And also I quickly want to make comments around the AU convention. The convention, if you look at the wordings of the convention, it's not something that automatically binding that once you sign it, then it means that's what you transpose locally. It's just suggestions, do this, have an independent data protection authority, have this right. There are so many even things that the convention ignores itself in terms of more emerging rights from data protection perspective, for example, even in terms of principles, in terms of legal basis. But signing is some sort of commitment. And also, if you also look at it, virtually every African country have different attitudes towards, the ones with laws have different attitudes to what their laws look like. Whether we want to talk about the material scope, whether you want to talk about territorial scope, whether you even want to talk about mechanisms for international transfer. If you look at what you have in Tunisia and Morocco, for example, you need the approval of the supervisory authority before you can move data out of the country. And I feel that's actually problematic too. If I have to, before I do that simple trade, so those are some of the things we need to change to make sure we bring some of our laws closer to what our reality is, and also to enable, to actually enable that digital economy potential we really want to unlock. So yes, that's my take on this.
Thank you very much, Ridwan. We're running out of time. But Amanda, just briefly, there's a question there that was raised by Ibrahim. And Ibrahim is saying, what is the place of privacy in litigations / court hearings, especially when it concerns personal data? Just briefly.
Briefly, Ibrahim, normally the right to privacy is where you find data protection. So you have that right usually from the constitution within your country. So you can definitely take any data protection case that you have, but you take it under the right to privacy and you can take it to court. In South Africa, it is mostly court cases that have influenced our data protection law. So if you had to trace it back, you will find that most of the principles that we have that deal with data protection all come from case law dating back up to early 2000s. So definitely, if you don't have a data protection law in your country, you might want to take whatever data protection case you have straight to court, but it will fall under the right to privacy, which is usually found in your national constitution.
Thank you very much, Amanda, for that. I know you could have said more, but in the interest of time, we have to round up. So I'll give you an opportunity, each one of you, to give us your parting words and also your comments around the future of data protection and privacy beyond COVID-19, especially after all this, so much information has been collected post-COVID-19. What are you parting with regarding that? We'll start with Ridwan. Charlie,
Yeah, thank you. Yeah, so I think from the take home for me is the fact that we need to do more as a continent. African countries need to do more. Currently, we have countries, we have the continent divided along the lines along the line of countries with laws, with data protection authorities, country with laws without data protection authorities, and countries without laws at all. So we need to bring everybody. We need to come closer to a center where we have more African countries adopting this, protecting this as a human right, because it's actually a human right, no matter how we spin it. And it's something that is really, really, really with us. We can't run from it. So we need to have more countries adopt. People need to become more aware about what is right, what the danger, what the risks are as well. And also for us individually, we need to drive the conversation, continue to engage, and of course, hopefully things get better over the next few years.
Thank you.
Thank you for the opportunity. Yeah, thank you.
Yeah, thank you, Hlengiwe. I have 2 triple points, and one of them is that when I look at the amount of fines that I see in some countries, where you will say that maybe Facebook has been fined for $4 billion. Those are things that, to just imagine that as Facebook is using our data, as so many other, data exploiters are using African data, it means there are space, to reap some value from there instead of going to borrow to the World Bank and I don't know where. There are hidden benefits in the way our data are being used, and the problem is that our leaders don't think, those who decide don't think to be aware of this potential. And that's where we need to, and I join Rewind and Amanda with it, we need to make those people aware of those kind of value that we can reap from the fact that multinationals are using our data unlawfully. But to get to this unlawfully, we need to have laws. If we don't have laws that are protecting us, it means our space are just open space, and anyone can just get here and make things as in 1884, when they came here and say, okay, this is just an open land, we will divide it. And it's happening right now on our data, and that's just incredible. That's my first point. My second one is that we need to push out this conversation. And I hope, the Center for Human Rights will need to. Yes, there are so many organizations in Africa trying to push this, but we need a kind of specialist pusher, someone that will be pushing this conversation, gathering people, not just bringing experts in this type of meeting, bringing people that will just bring their insight, their mindset, that relates to any other things that is just close to data protection, because whoever you are, wherever you are, your data today is being used, and at times even at your expense. Google has been harvesting even data of those who don't have a smartphone, and this is just to tell you. So that's where I would like to give you the mic. Thank you.
Thank you, Amanda.
I want to see apps that have trust by design built in. I want to see every organization that collects personal data to ensure that they are protecting individuals' privacy, and this should not be an afterthought. I want policies to push for this, push these organizations to account for the way that they collect, store, process individuals' personal data. I think people should be able to share their personal data and should know that these organizations that we're sharing our personal data with are accountable and will treat this data with respect, and they'll respect everyone's right to privacy. So that is what I want to see for Africa and for the world going forward.
Thank you so much to our speakers for their passionate interventions. And also thank you very much to our participants. You've been quite engaging. We got questions and comments from the chat section. And also please remember to participate in the poll that was shared. So as a Center for Human Rights, we are continuously engaging on this issue of privacy and data protection. And like I've mentioned, there is a call for abstracts. Please participate, share your abstracts with us. We are hoping that we are going to have this conference where we can have broader conversations around this area. If you notice on the call, we have different thematic areas where we will be able to address issues on national security, issues of surveillance, issues on children and privacy, issues of socio-economic rights. So we'll be able to do that more broadly. Like right now, we only had like 1.5 hours, and you can only do so much within that time. But also coming up, we'll also be having a MOOC, massive online course on privacy in the digital age in Africa. And in due time, we will be able to advertise that, and you can also participate in that. But otherwise, we're also inviting you to join our other human rights talks. This is just one of the series. Every week we have them on Tuesdays and Fridays. We touch on COVID-19. We touch on different aspects of human rights. So like we said, this session was being recorded. We'll be able to share that recording on our website. Also, I think in a week or so, we'll be having that the recording. But otherwise, thank you to our participants. Thank you to our speakers. Have a lovely day. Thank you so much. Bye.
Thank you. Thank you.